was enough. So our former Chief Justice, Scott Bales, looking at the problem, and what is the problem? And ultimately, it comes down to that legal fees just are out of reach for most Americans. And certainly in Arizona, most people cannot afford an attorney. Now, certainly they can afford an attorney if there's something very transactional like a will or a trust. They can do that, or a lot of people can. But when you get into a civil dispute, criminal case, unless you're indigent, the people simply cannot afford an attorney. And the amount of need is great. We also notice several professors, researchers have studied the billable hours across the nation. And what they're seeing is that law firm income is up when law firms work with businesses, corporate law. And in fact, the fastest growing area of law is general counsels. But the amount of billable hours from what we call people law, lawyers that work directly with people, is down and is shrinking. It's becoming a smaller part of the practice. In across the country, and I can tell you in Arizona, it's even higher, the majority of cases now that come into our courts have at least one party represented by themselves. And in our divorce courts, it's probably now close to 90% with one party and 75% with both parties. Also, when you look at civil judgments in the United States, the dollar amount's very low. I know we always talk and hear and read about large judgments, but the median judgment's only $2,400. In my state, the majority of cases are under $10,000. So these are not cases that tend to attract most attorneys. This particular slide I'm going to show you lays out what it would take if we were going to try to use more pro bono hours to meet some of the legal service needs that exist in the country. This was a slide done by Professor Rebecca Sandiford, who's now at the ASU Law School. And she calculated the need and then said, well, what would it take if we just had lawyers providing 1 hour of pro bono service to the need? It would take 150 hours a year from every lawyer in the United States. It's just not practical, whereas the current level is much, much lower than that. And in Arizona, we tried pro bono. We've tried all sorts of things to get more lawyers volunteering. And we do have a lot of lawyers that volunteer a number of hours. Unfortunately, it's just not anywhere close to meeting the need. And so you've got this dilemma. For the consumer, the legal costs are rising faster than CPI. Consumers are skipping legal services provided by lawyers altogether. They're doing more and more by themselves. And there's a growing market out there of do-it-yourself services that are not connected to the bar, not regulated by the Supreme Court of your state or your bar. On the other side, we look at lawyers, and when you look at solo and practices where they really do focus on people law, we're finding that lawyers typically bill only about 2.3 hours a day of real legal work, and the rest of it's spent on management, marketing, personnel, other issues. Lots of lawyers go to law school, but don't come out as marketers. They're not necessarily business people. They don't necessarily have a strong affinity with technology. Now, there's exceptions to this, but we're finding that they don't really have the affinity for building a high volume practice using technology. And as I mentioned, we have fewer lawyers servicing people rather than businesses. Now, the World Justice Project rates the United States 99th out of 126 countries in the world in terms of the affordability of civil justice. It's really kind of an embarrassment. But that's just the reality, that we have great lawyers, we have a great system if you can afford it. It's just that most in the United States cannot afford the system. Some studies have shown that 86% of civil legal matters reported by low-income families receive little or no legal help. So, I don't want to belabor the point. I think you're probably all aware there's a gap, and you say, what do we do about it? Well, there does seem to be a national movement that's starting to take hold. The Conference of Chief Justices, that's the collective, all of the chiefs in the United States state courts together, meet a couple of times a year. And at their last meeting that they were actually able to get together at, they passed a resolution calling on all states to look at regulatory innovations and reform. They didn't come up with a specific proposal, but they think all states should take a look at this. And even the ABA checked in, and they passed a resolution. While they call for maintaining Rule 5.4, they also are encouraging courts and jurisdictions to consider innovative approaches to the access to justice issue. Now, when our task force got together, it was created by Chief Justice Scott Bales, now retired, and it was chaired by our current Vice Chief Justice, Scott Timmer. Their conclusion was, when they stepped back and looked at the rules, some of the ethical rules, particularly 5.4, they believe those rules stifle the delivery of legal services, not promote it. And the technology is already here. People are finding things online. There's all sorts of groups like Rocket Docket, LegalZoom, and there's actually hundreds of these groups out there now. And they're really not regulated, and they kind of skirt along on the edges of what's ethical and what's allowed in different states. So we created a task force to take a look at this entire issue. The task force, I just went back and looked recently. We actually completed our work in 9 meetings. Now, we did have two subcommittees, and they met periodically in between meetings, but we did our work from start to finish in 9 meetings. They made 10 recommendations to improve the delivery of legal services. Today, I'm going to focus on just a few of them. The first one, I think, is the one you're mainly interested in, and that is what we wound up calling legal paraprofessionals, or LPs. Now, I want you to keep in mind that over 15 years ago, our court authorized non-lawyers to practice law called legal document preparers. We have 700 of those. We've had them for years. They don't get a lot of attention. For some reason, people focus on Washington State, where they have a very small number of practitioners. They had a model that was doomed to fail from the beginning, and I can go into the details about that. But we have 700 document preparers, and they've been providing services now for over 15 years. We get very, very few complaints on the document preparers, hardly ever a complaint from a customer. Sometimes we'll have lawyers complaining that they're doing too much, that they're exceeding their authority. But that program has worked fairly well. We regulate them. We regulate their firms and the individuals here in Arizona. And I say we've had about 700 of them. But we found that's not enough. As I mentioned, we invented self-service centers in our courts. We have centers all over in our courts, in our superior courts throughout Arizona. We also have, I heard you talking about the York program where they have navigators. We have an AmeriCorps grant program that provides college students that we train to serve as sort of navigators between the public and citizens who come into our courts. So if you want to look at a first step, that's something to consider, because if you apply and receive an AmeriCorps grant, you can actually pay a reasonable cost to students and they get college credit. And that's worked out really well for us. But it's not enough, because what we find with all the services we provide is that people still cannot go into the courtroom and articulate their case in a factual, non-emotional way. That's particularly true in family court. And so we're taking the next step with these LPs, legal paraprofessionals. Now, they're going to be non-attorneys. They're going to be licensed to practice in a limited area, but they will be practicing law. Let me go back one slide here. They're going to be required to have certain education requirements. There will be a testing regime, a little different than this bar exam. It'll be really testing on the substantive law of the areas they want to practice in. They'll be limited in scope, more similar to a nurse practitioner, like a doctor compared to a nurse practitioner. And we hope that they'll be able to service middle and low income folks. Now, the areas that they're going to be authorized to practice in include family court, Our limited jurisdiction courts. Now, in Arizona, we have the superior courts. It's our general jurisdiction felony level court. But we also have justice and city courts. We call them limited jurisdiction courts. In those courts, you have traffic, criminal misdemeanor cases, and civil trials up to $10,000, civil judgments, civil suits. But I want to pause there because the majority of our cases are under $10,000. So we also have evictions and credit card debt cases in limited jurisdiction courts. And this was a surprise to me, but we have judges and folks advocating that they also be able to practice in criminal areas in our limited jurisdiction courts, but only when jail is not a condition. We have a lot of cases where someone's charged with a misdemeanor offense, the prosecutor waives jail as a possible sentence, but they still may sit in jail because they can't make bail, actually longer than if they were found guilty and were sentenced. And so these folks, because they waive jail, they're not entitled to an attorney to be appointed for them. And this is an area we hope that LPs might be able to fill in. And then administrative hearings. So interaction with the government, welfare programs, motor vehicle, special education, but all the plethora of administrative hearings is the other area that they're going to initially be able to practice in. They will be practicing, they will represent clients and be able to go into these proceedings and represent them. Now, some people say, well, will people use them? And I guess that remains to be seen in Arizona. But in other countries where non-lawyers are available and where lawyers are available, people do use non-lawyers. You know, it is interesting when you get out of the United States and you find out other countries don't regulate like we do. The UK is a good example. All of their family practice in the UK is really not regulated. You don't have to be a solicitor or a lawyer in UK to represent people in family matters. But we've had people, non-lawyers representing people in a variety of areas for many, many years. In my state, we have what's called Rule 31. And that's what governs who can practice law. And coincidentally, we had 31 exemptions in Rule 31. And so we had legal document preparers, we had the tax specialist, and on, a list of people who could practice in our courts today. Also, we absolutely know non-lawyers can practice law successfully. In Arizona, 50 years ago, our Supreme Court issued an opinion that said conveying of real estate, writing contracts, modifying contracts, and so forth, is the practice of law. That didn't set well with the real estate agents, and we have what's called the initiative process in Arizona. So they secured the signatures, went to the ballot, and amended our Constitution to specifically allow real estate agents, licensed real estate agents, to practice real estate law in Arizona. Well, they've been doing that for 50 years, and we have no big problems. Now, I know a lot of the states in the country still require a lawyer to convey real estate. They do that in England too. You have to have a lawyer. But in Arizona and many states, in the West at least, you do not need a lawyer to convey real estate. So we know there are places that the non-lawyers can practice law successfully. The trick for us was, well, where are those areas? Where can people be trained? What kind of education and qualifications do they need? So here's a little animation we did to help explain our LPs, our legal paraprofessionals.
Dave, I don't think we can hear the sound. Is there supposed to be sound with the animation?
Yeah, there is sound. You're not hearing it because I'm hearing it great.
No, we're not hearing that right now.
Okay, well, then I'll just skip over it. It's available if you go to our website. We have a website on this whole program, and these animations are there. So if you want to take a look, these are about 2 or 3 minutes long, and I've got 2 of them. I'll skip this one, and I'll skip the one later on if you can't hear. Now, I wanted to play these particularly because when you decide to do something, and if you decide to do something, you're also going to have to consider how you promote it with your Supreme Court. And I wanted to play it so you could see one of the things we did that we use with the public and with the court and others. But we can talk about that when we get more into the questions and answers. So one of the questions that does come up is, and usually one of the objections that lawyers will have in doing something like this is we lawyers want to protect the public. The quality of the work won't be good enough if you have non-lawyers doing it. But actually research in places where this has been done for a while shows that's just not true. If you go to England, there's been several studies now where they look in blind studies at documents like wills and divorce proceedings, or they do survey work. The surveys show that actually the non-lawyers can score higher in terms of how satisfied the customers, the clients are than the solicitors. Here's one graph, again done by Rebecca Sandiford, showing the competency level. There's a combination of looking at the quality of their work and how people felt about their work. And you can see that the solicitors do well here in terms of good work, but when you get to the excellent, the non-lawyers actually achieve a higher excellent rating, a higher percentage than the lawyers. You say, well, how is that possible? Well, it becomes possible because when you're talking about something like a will, if all you do are wills and trust, whether you're a lawyer or a non-lawyer, you get very good at it. But a lot of solicitors do a lot of things. They're generalists. And so wills are only done occasionally. And so when they look at it, it turns out that the non-lawyer advisors who tend to specialize in an area tend to do better overall than the solicitor's work. Let me also move my screen here. Another example does deal with wills. Now this is where, again, they did a blind review of the actual quality of work. And here's what lawyers and experts, how they graded the work quality done by both the solicitors and the non-lawyers. You can see on the will writing, the light blue is the non-lawyers, the sort of purple dark blue is the lawyers. And when you got to complex work, actually the non-lawyers seem to be doing better than the lawyers. And you can find these studies and others around the world where this work goes on. But our task force became convinced that the argument that non-lawyers couldn't do quality work just wasn't true. Now, one of the things we did do was after our task force came up with its recommendations, I anticipated that we would get a lot of negative comments from the lawyers. And this isn't to put lawyers down or to be hostile towards them. It's just expected. Doctors weren't in favor of nurse practitioners when they started 40 years ago. They opposed them, but today they wouldn't have the same view. So what we did is we commissioned a public survey of adults in Arizona. And when we explained what LPs were, over 80% of the citizens in Arizona supported the idea of adding LPs to the people who could deliver services in Arizona. I should point out, when that real estate initiative went on our ballot, it also passed by 80%. 80% of the citizens voted to allow real estate agents to practice real estate law in Arizona. When we took the ABS program, even lawyers, we broke down the question, if you're a lawyer or if there's a member in your immediate family who's a lawyer, and then asked them the question, 84% of those people supported the creation of the LPs in Arizona. We also explained to people about law firm ownership and then asked them if they thought it was a good idea to let non-lawyers partner with or even own a law firm. And in that case, well, let me explain what it is, and then we'll give you the poll. So this is really the Rule 54 requirements. And our task force, after looking at different models, different ideas of amending Rule 54, decided simply to abolish it. When you go back in history and you find out why was Rule 55.4 created, it really was created to protect law firms, not to protect the public. And we have other rules that we think protect the public just fine. And our recommendation was to completely eliminate 5.4. So in Arizona right now, you can own a law firm and not be an attorney. You can partner with a law firm. And we don't think, what we are hoping, we can do it in a way that still protects the public, but creates a atmosphere that allows for new innovation in the delivery of legal services. We just opened up the application process in Arizona. We have our first application already in. We've had numerous companies and groups and firms talking to us, so we're expecting more applications. We'll see how it goes. Washington, D.C. has, in a limited way, allowed non-lawyer ownership or partnership for many, many years. I know they're looking at expanding that. It's limited. Arizona has gone much further. And in Arizona, our regulatory system is to regulate not only the lawyers involved in this, but the firms. And so in order to make this work, you have to regulate the ABS itself. And the consequences for improper, unethical work would be the revoking of your license to practice in Arizona as a firm. We already do this. We've had years of experience doing it with court-appointed fiduciaries and fiduciary companies, legal document preparers and document preparer companies, court reporters, defensive driving schools. So we already regulate both individuals and firms. So it wasn't new to us. It's something we've expanded, and that's the model we put in place. It is a different model than Utah. It still requires a lawyer to be involved, but that's where we are with our ABS program. Now, we ban certain people from participating. You can't be a disbarred attorney and be any part of an ABS. The ownership has to go through a character and fitness study. Any complaints against the owners, the non-lawyers, are still going to be prosecuted by our state bar. We did that to take advantage of the lawyer discipline system infrastructure we put in place. We re-engineered that a number of years ago. We have a very good system in Arizona. And so if there is a complaint brought against a ABS, it could be against an individual in it. It could be against an attorney. It's part of an ABS, or it could be against the firm. It all goes through the state bar investigation and prosecution system. So we didn't want to rebuild that whole thing. As I mentioned, it has to include at least one licensed Arizona attorney as part of the system. Okay, I'm going to assume you can't hear that again, right? That's the other animation, so I'll just skip through that. But if you want to take a look, it is on our website. So we also took the issue about ABSs and non-lawyer partnership and ownership to the public. And the result there was 62% favored doing it. Now that's less than the 80% for the LPs. But if you were running, if any of you were involved in political campaigns, if you were getting 62% of the people wanting something, that's like a landslide. You know, if you're trying to pass a constitutional or statutory change with the people. So there was very good support for ABSs, although admittedly, it's a little more difficult to explain an ABS and lawyer ownership. As a matter of fact, when we broke out the data and asked the questions about who can own a law firm, many of the lawyers who we asked the question to didn't know that the non-lawyer couldn't own. So it's just not something that's all that well understood. You have to explain it to the public and then ask them again. Okay, so we did the poll. There was support for both of these. When we went into it, we had no idea what the results would be, but they were very supportive, and that was part of our method that we used to then lobby or move this through to the Supreme Court and get it passed. Now, there were other proposals from our task force. I won't spend time on them, but there were things to improve our document preparer program, giving them a little bit more authority, allowing them to do more legal research. And there were other recommendations. We have an unbundled legal services rule. We've had it for years. It really has never gotten legs. Some lawyers do it a little bit, but we're going to try to reemphasize it again, but it just never seems to take off. We've modified our advertising rules and relaxed those some more. We allow law school grads who are awaiting the results of the bar exam to practice under supervision. That came in pretty handy this year with the pandemic when students didn't want to sit for the bar exam. If they wanted to go to work, they could go ahead and go to work under the supervision of an attorney, but then they had to take the next available bar exam. If they passed, fine. If they didn't, they'd have to stop. But that was a rule change that our court made, and it was helpful. So, as I mentioned, our task force met 9 times. It made its recommendations at the end of the year. We then went through about a 9-month process to flesh out the proposals and to educate people, take input, and then take it to the court. Effective in August of 2020, our Supreme Court adopted all of the proposals. Now, they tweaked some things, improved on some areas, but they really adopted all of the recommendations in substance. We also have a judicial council. It's like our board of directors that deals with the administration of our courts. It adopted what we called code sections in October of 2020. So the Supreme Court, by rule, laid out the broad policies to authorize all this. Then we had to write detailed codes, which I've given you a link to. Those codes were written and worked through a comment period and then adopted by our Judicial Council in October. So the current status of where we are in Arizona. All of these rules are now in effect as of January 1. We created an ABS committee, which is very similar to like a character and fitness committee. It's chaired by our former Chief Justice. It has both lawyers and non-lawyers on it. It's had its first meeting to get orientated, and it now will go to work reviewing applications and recommending approval or not. We have our first application. The LP program the rules are in effect, but we had to do the work to get the test ready to test and provide an exam to these folks. We hope that they'll be ready next month, and by March, probably, in theory, we could start having applicants and start testing people. But that's going to depend because based on your education and experience, there's various things you have to do before you can sit for an exam. So my guess is applications will really gear up later this year. Our law schools and colleges and paralegal community college programs are kind of gearing up, changing their curriculums to accommodate the LP program. So that may take a while to really grow. So that's kind of it in a nutshell. Let me stop sharing so we could see each other. And then I'll be happy to respond to any questions you have, both on what we've done and also I do want to spend a minute or two, I'll let you ask questions, but talking about how you get from whatever you do in a report to actually getting it implemented.
Thank you, Dave. That was great. I appreciate it. I see Alice with a question. Is that a question right away, Alice? Go ahead, jump in, and we'll just go around, and we've got plenty of time, so far away.
Yeah, Dave, so as I understand it, it looks like these initiatives were really all under the auspices of the court, and that it didn't involve any legislative process where your state legislature had to get involved in making laws and that political process. Am I right?
That's correct. In Arizona, the regulation of the practice of law is solely under the jurisdiction of the Supreme Court. And so the Supreme Court is so said. And so we don't even have a UPL statute in Arizona. They abolished that years ago. So really all the regulation of the practice of law is done by the Supreme Court. That did make it easier. Although I can tell you, I met recently with some senior legislators and their staff, and when they heard about this, they couldn't believe it. They were so excited. Some of them were trying to sign up. Legislators wanted to know if they're in the legislature on the Judiciary Committee, could they qualify? I mean, there was a lot of enthusiasm. Also, be aware our governor has been one of the governors kind of leading the charge across the country on deregulating businesses and professions and having reciprocity with other states. So there is kind of an atmosphere with our legislature and governor. I think they would have supported this too, but we didn't need to do that.
And then I had another question, but it takes us in a little different direction. With regard to the paraprofessionals, I know there's an exam. Is there an educational requirement and is there an experiential requirement?
Both.
Okay.
Yeah, and I've given you a link to that section of our code. It varies, and so you kind of run the gamut. So you could have a person who graduates from a paralegal, an ABA approved. They don't approve them, but an ABA certified. I think it's called a law paralegal program. And I think they need 1 year of experience. You have different requirements if you have a BA degree or a master's degree, or if you have a law degree. So for example, our University of Arizona is one of the first universities that has a BS in law. So we've recognized that credential, and they're actually modifying their program a little bit to meet the requirements. And if you graduate from that, you could sit for the exam. Also, if you graduate from an ABA law school, but don't pass the bar, you're qualified to sit for an exam. Because when you think about, we all have students that don't pass the bar, but they still have graduated from a bar school, an approved law school, and have knowledge. So anyway, it kind of depends on the level of education. Also, we have a program or a provision that says if you've served for, I think it's like 7 years as a paralegal, even without a paralegal degree in a law firm in the area that like family law, then you can be recommended by your lawyer and sit for the exam. So we carved out different levels of experience, education, so on, and that allows them to sit for the exam.
Great.
And part of our thinking is we also have the universities working on a certification program. And this is going to be aimed at professionals, but not lawyers. But for an example, social workers, nurses, or we have, and I don't know if you do in your state, we have quite a number of family law, divorce mediators. They're not lawyer, but they're mediators. And those mediators have, might have master's degrees, and their clients will come in, they negotiate maybe the entire divorce except, let's just say one thing. Let's say they agree on everything but spousal maintenance. Well, if they become an LP, now that mediator will be able to come into court as long as the clients have waived the conflict, and they can lay out in a factual, non-emotional way, Judge, they agree on all these things. They don't agree on spousal maintenance. Here are the facts. Here's the number of years they've been married. Here's the income, et cetera. And you decide this one item. So we think there's going to be a number of professionals who have years of experience in the housing area, the medical area, so forth, that will want to get the credential to be able to come into court and add that to their practice. So that's also being developed right now.
David, can I ask another follow-up,
Yep.
Mark?
Yep,
I don't
go
know if
ahead,
anybody
Alice.
else, I don't mean to monopolize things, but so what was the politics like with the regular bar with all these proposals? How much pushback was there and how much ability did they have to push back? Or was there actually some embracing of these ideas?
Well, good question. I saw what happened in California when they made their proposals, and then there were hundreds of lawyers that opposed everything they proposed. So, and I recognize the same thing happened with doctors. I mentioned that with nurse practitioners. So I anticipated that we would get mostly negative comments. So when we have a process that's very open, when once these recommendations were made, they were turned into rule petitions that are posted publicly, and that people can comment on each rule petition. And code sections, the same thing. And so when we posted it, we did get more negative comments than positive. There were some positive comments from lawyers, but mostly negative. And it usually revolved around these people wouldn't be ethically right or educated enough to do the complex work they're doing as lawyers. Those were the exact same arguments they made against real estate agents 50 years ago, exact same. But they're legitimate. But we also had some lawyers who were on our task force who were meeting privately with law firms and lawyers. And frankly, the biggest concern was money and competition. You know, they didn't want to say that necessarily publicly, but you got to realize it's there. And solo attorneys who are doing family law, they're maybe struggling already. They say, oh, okay, here's some competition. So you got to recognize that that really is there, whether they say it or not. And so we held several meetings with the bar. We did seminars, webinars, we did meetings. I think we were still meeting in person back then. But we never thought we would be able to convince the bar board to support this. I was hoping for a close vote, you know, like 49-51. But one of the differences, many years ago, our Supreme Court made a decision to put public members on every policy committee we have in the court. So we have lots of them, including the state bar. So we had public members on the state bar. They took 2 votes. The way that our process is, they vote, they discuss and vote once, and then they vote again to approve it. First vote was opposing. We came back for the second vote, and after the discussions and the public members spoke in favor, it reversed it and they voted to support it. So we, to our surprise, got our bar vote to support these. But we also went to the public. We did the public poll, and we also commissioned a group to do 6 or 7 public meetings, focus groups. And the pandemic hit right when we were doing those. I think we got one held actually physically together, but then we did public Zoom meetings with folks. And those were very good to get the people who are dealing with low-income folks and low-income folks themselves. All of that came and was summarized, and that comment was all given to the court. All of that was highly supportive. And so by the time it got to our court, the court was hearing negative comments from lawyers, positive comments from the public and others. And our Vice Chief Justice very wisely planned a series of educational events with our court. So by the time they got to the decision-making time, they were already completely up to speed on this and knew the pros and cons. And that's the point I want to make. Illinois just submitted their report to their Supreme Court. If you do that, that's all you do, you're not going to get anything passed. You really have to have a plan of how you take whatever you decide to recommend, if you do, and work it through that process, whatever that political, human process is with your court. You got to really think about the strategy and how you involve not only the lawyers, but the public to get you from one point to another. I see some hands up.
Right.
So
Yeah, I do too. Let's see. I think it was Colin first, then Jeff, then Marcy.
I'll
Colin,
try to
go
give you
ahead.
shorter answers.
Yeah. Thanks, Dave. We really appreciate you being here and helping us with this. I was wondering if your program has been in existence long enough that you've been able to collect information about the number and types of services that have been delivered to consumers by the LPs, and whether you can identify consumers as folks who have not previously been served, or whether we're now serving folks at a lower cost, or just, I mean, we've been very concerned about the unserved and the numbers that you've talked about, and trying to focus on how we serve these people who currently don't have any legal services.
So the quick answer is no, because our rules just went into effect January of this year, and we don't have any certified LPs yet. And the same thing with the ABSs, we just have our first application. However, because we had the LDPs, the document preparers, for over 15 years, we do have data. And I have another chart and graph that I can get to you that shows the kinds of activity that they're involved in. But also during our process, all of our task force meetings were done in the public, and we had lots of people coming and testifying, including the LDPs. And I'm reminded about a lady out of Prescott, Arizona. She's a document preparer. I wish I could clone her. She's the exact, what we had in mind, the nurse practitioner type model. She's not only an LDP and practices in family and juvenile work, but she's also a registered tax agent or whatever that is. So she can go in and represent people before IRS. And so she did both. She represented people before IRS administrative bodies and has been in court. I talked to her several times. She testified. Her entire practice is moderate and low income folks. She says she makes a nice living. She services the people, and the lawyers in Prescott, Arizona are doing just fine. They're booked up solid. So I know it can be done. She's a prime example. But if you want better data, the place to look, the best program, I can save you time, the best program in North America is Ontario, Canada. They call them paralegals. That's who we modeled our program after. We brought them and had them meet with our court a couple of times. They have had thousands, and they have, I think right now, it's either 4,000 or 6,000 licensed paralegals. Some of them work with law firms, some work independently. There's been 2 or 3 complete, thorough evaluations of their program. The lawyers in Ontario are thriving, and so are the paralegals. They're renewing, so they're doing well. And in fact, during the period of time that they were created, I believe the numbers, there's been 10,000 attorneys added in Ontario, that province. So that it's not depressed the legal business at all. And I also can tell you, both from our experience and Ontario's, is that the percentage of complaints against the non-lawyers is lower or equal to the lawyers. And that Ontario will confirm that if you talk to them. They don't have any different level of the citizens complaining against the Ontario paraprofessionals.
Thank you.
Thanks. Jeff Summerlin Long?
Oh, and also the cost of the paralegals in Canada is less. So we're hoping that the paraprofessionals, the LPs in Arizona, will bill at a lower rate. They, of course, won't have the heavy debt burden of a student coming out of law school. So we hope that we'll achieve that.
Hey, Dave, thanks again for doing all this. I'm Jeff Summerlin Long. I'm a professor actually at UNC, a former legal aid attorney. My question has to do with the real estate agents and their ability to actually finalize the transactions. Are they required to have IOLTA-like accounts?
Not that I know of. The real estate agents are regulated by our real estate department. So they have to pass a test and be certified as a real estate agent in Arizona. I can't say that I'm intimately familiar. So I don't know if they're required to have any sort of similar trust account. They don't have IOLTA. IOLTA, of course, is where you direct the money to go, the interest to go to legal aid. But I don't know if a real estate agent, it's usually, I think when you do a real estate transaction, it goes into escrow. The escrow companies are the ones that hold the money, not the real estate agent. And so the question really should be, do escrow companies need to have an IOLTA account? In Arizona, they do not. We actually looked at that, of trying to get that money, the interest on that money, to go to legal aid, but we've never achieved it.
Okay. Yeah, I mean, I'm honestly not sure how it even works in North Carolina with real estate transactions. My understanding was that was a part of IOLTA, is it not?
Yeah, that's correct.
So an attorney, do you have escrow? I mean, attorneys would be on each side. I wouldn't think each one would hold the other's money. I don't know how it works in North Carolina. My experience, and it's always been with escrow companies, where the parties put the money in escrow and then the escrow company disperses it at the end of the transaction. But
right. Yeah, no, I mean, my concern is just that, like I said, I believe in North Carolina, real estate attorneys do put the money into an IOLTA account. And
That's correct.
IOLTA is a huge source of funding
Sure.
for legal services in North Carolina. And I wonder what kind of impact something like that would have on the actual funding. But I guess institutionally, Arizona is different. So we can't really find out.
We never, at least for 50 years, we've never had that. And of course, the interest rates are so low now, IOLTA is not doing particularly well. But the idea, you reminded me, the idea did come up to require the escrow companies, since they're holding that money, to do the same thing, put it into an interest-bearing account and give it to legal aid. That would require legislation, and in our state, no one's ever accomplished that.
Yeah.
But in your state, if you change, you could do the
Thanks.
same thing. Yeah.
Great. Let's do Marcy and then Camille.
Hi, Dave. My name is Marcy, and I'm sorry I'm in the car, so sorry you don't get to see me right now. But thank you. Your presentation has been very interesting. I'm a family lawyer, so my question is, what exactly can an LP do in family court, and are there any limitations on what they can do, either by issues or by the size of the marital estate? So what does that look like?
Yeah, yes. So they can do most things. What they can't do is what's that called? When you're dividing up a pension, a defined benefits pension, there's an order.
QDRO, Qualified Domestic Relations Order.
Yeah, we call it something a little bit different. But what we did is we said if anybody who wants to do those that are not lawyers have to also pass a special exam. So we're going to have an exam for that. And the reason is right now our lawyers don't often do those. I don't know if you do, Marcy, but often they have an accountant or somebody else that does them for them. And so we recognize there might be accountants that might want to do that themselves. So that's going to require a special exam. So an LP could get there, but they have to show that they are qualified. And then we did limit the LPs from doing what I'd call high-end complicated divorce business transactions where you have say a doctor's business that's being divided up or a dentist. So there is a limit on what I'd call more complicated high-end business transactions.
So
frankly, that's where our family law lawyers are. They're not doing typically the mom and pop divorces. The mom and pops are going into our courts by themselves.
Okay, so cases, so they are limited by the marital estate. Well, if there's a business involved, or like you said, complicated issues, because they could be business valuation issues, tax issues. So there's a limit on what they can do, because when you did your presentation, you just said family court. So I was thinking, oh my goodness, they can go in and do anything in family court.
Yeah, there are some limits, and time will tell what what works and what doesn't. The truth is, I bet you when you came out of law school, you didn't know any of that. And so you probably learned it since law school. But we recognize there are some complications where it's like in the medical field. You don't go to a nurse practitioner for brain surgery. And so that's what we're trying to recognize, that there are legal transactions that are simpler, that don't require a JD level lawyer to do everything. And we're trying to find where those areas are and still let our lawyers really be the predominant ones to do the complex work.
Thank you.
Thanks, Marcy. Camille?
So Dave, you mentioned that there were some of the traps that or failings that Washington State had with their triple LT program that we could learn from and avoid. So would you speak to that for a moment?
Yeah, when the triple LP program was created over a decade ago, the bar was very hostile to it. There was a very bad relation between the Supreme Court and the bar over that. And as they went through it and compromised, they made a lot of compromises that they shouldn't, and they overly structured it. When I remember when I first saw it, I told my deputy, this will never work, because the requirements of education and then serving under a lawyer for thousands of hours was going to wind up producing a triple LP that was going to be clearly almost as expensive, if not more, than a lawyer. And I looked and said, this isn't what the right model is. I was surprised it lasted that long. And they never had more than a couple of dozen, I think, triple LPs in Washington. I wouldn't bother with that model. It's not something to follow. I think the people involved would tell you that. It'd be better to look at our document preparers, or I think the Ontario program is the way to go. I wouldn't waste my time. And I think you just can't create something that's so complicated and take so many hours that you're really producing just a little attorney with a lot of debt. That's what you're trying to avoid.
Thanks, Dave. Heidi?
Thanks, Dave. I'm Heidi, and along with Marcy.
Wait, before I go on, one more thing. Additionally, the triple LPs in Washington couldn't go into court. That was the other big thing. They were more like our document preparers, but they also limited them to family law predominantly, where our document preparers can do much more. They do trusted estates and all sorts of things, paperwork-wise. And therefore, I think our document preparers, they've been able to build a practice because it's much broader than what they did. So Washington limited the scope, and they couldn't go into court until the last few months. They did pass a rule to allow them, but it never took off. I'm sorry. Go ahead with the next question.
Go ahead. We'll do Heidi and then Steve.
Okay. Thanks. I'm Heidi, and along with Steve and Marcy, practice family law. And we've heard repetitively about the need for services in that area. But I'm also trying to visualize that in practice. And so I sort of had 3 questions, and I might have missed this when you said earlier in your presentation, but is there any sort of vetting or qualification process for the consumers who are trying to receive the services of the certified LPs? Like, legal aid, you have to qualify, or can anyone seek one?
Yes.
Okay.
We didn't think, in the free market, we didn't think we could control someone's private practice that way. So no, they could work for anyone. And our document preparers work, some of them work for high-end construction companies preparing liens for them. Others work for low-income people. So no, we don't have any requirement that says you have to be low income.
Okay. So then is there any oversight on the rates charged?
No,
or
not
limitations?
any more than an attorney. We treat them the same way. We don't regulate what attorneys charge, and we wouldn't regulate the document preparers. It's the market. And the idea is, if you want to be in this market, you're going to have to be competitive and hopefully charge a lower rate, or you won't be in business. Because if you could choose a really experienced attorney for the same rate, why would you go with an LP?
Right. So then are they, at least theoretically, I mean, it sounds like it's so new, we don't know yet, but they're held to the same standards as lawyers are, as far as the rules of civil
Ethics.
procedure and the rules of evidence, and
Yes.
even in court.
Yes. But let's face it, in family court, I mean, if you're practicing, I can't imagine North Carolina's, well, I assume they're not different. We have so many pro se litigants, they don't know the rules now. And the judges are trying to sort it out and deal with, sometimes a lawyer on one side and non-lawyer on another. I mean, it's like a free-for-all. And when 2 parties run representative and they're trying to cross-examine each other, my God, it's awful. And so what we're trying to do is bring in a professional at a lower cost that people will be able to afford. But it's their choice. I mean, it's a consumer choice, decision. Just like you could right now go to an LDP, a document preparer in Arizona, have all of your paperwork filled out, and then go in and represent yourself.
Okay.
But it's that representation it's still a big problem in Arizona, even with the other services we provide.
Thanks.
And so also we used to have a ban before this task force. A document preparer couldn't work under the supervision of an attorney, and there were reasons for that. But we decided they didn't make sense anymore. And so before, we did have some firms like you, like a lawyer who ran a family practice, but then owned a separate document preparer practice. Now they can merge them. And so the idea is, and you can have LPs working also with a firm. So your firm could broaden, and you could have, say, the lower dollar, simpler divorces, couple of kids and $10,000 in total assets. That might go to an LP, and you're still maybe providing some supervision, but you're taking the more complicated business divorce type work, but your firm's now handling both. And you could even have document preparers in your firm and let them just do that work if that's what they wanted. So the idea is you'd have a variety. You could broaden your practice and probably take on more clients and customers than you would today. Sometimes people come in, like with the unbundled service. I had a daughter that got divorced, 10 or 15 years ago. And I can tell you, when I went out with her to try to find a lawyer, it was hard. And every lawyer wanted $10,000 retainer on each side. They didn't have that. They didn't have that kind of asset. And nobody really wanted to just review the paperwork. But you can imagine now a firm where you have a document preparer in the firm, and then the lawyer gets paid for a couple hours of work to review all the documents and maybe even give advice to the client, who then goes and represents themselves. That's one thing. Or you could have an LP go and represent them, or you could represent all different price structures. That's kind of the innovation we're hoping for.
Great. Steve Robertson.
Thank you for your presentation, Dave. I'm frequently have this thought, and you just segued into it when we have these discussions with people around the country about why the model doesn't work that we have now in the regard that you just said, where, you know, Heidi Bloom doesn't do draft every pleading and draft every, review every financial affidavit in a marital case. She's got people that help her with that, and they get paid at a lower hourly rate. So I would like your thoughts on why that model, which we have now, and North Carolina has for many years been very friendly to the kind of a self-representation with a lawyer assisting, essentially ghostwriting has been permissible under our rules for a very long time, as long as I've been practicing. And so why can't that work in the system we have now? And unbundling it, I think there is a trend to that.
Well, in my state, even a paralegal working under the supervision of an attorney is probably billing today at $125 an hour, at least 100. And then you've got the attorney overhead on top of that, because the paralegal is not going to go into court. And so many people come in, and lawyers, like say with my daughter's experience, it was $10,000 retainer. They didn't have between them $10,000 in assets at that point. So that just wasn't going to work, because if they wanted to engage the lawyer, they needed to spend $10,000. And yes, a paralegal would bill some work at $100 an hour, but you're paying the lawyer also. The unbundled services, we've done that. We've had that for 15 or 20 years, and it just never gotten legs. And I can't find anywhere in the country that it has. When I talk to lawyers, there's two things that come up. One, they say, well, I'm fearful that the judge is never going to let me out of the case, that it won't be just an unbundled service. I think that's more urban legend. I can't find judges that do that, mostly because when you do unbundled work, you don't represent them in court. You don't go to court. You don't file a notice of appearance. Usually you're looking at their paperwork and giving them advice and strategy on how to go in on their own. So I think that's more urban legend. But when I talk to the lawyers, they say, you know, it's just more lucrative and easier to run a practice when you get a full client from start to finish. And right now, our lawyers are doing well in Arizona, and there still are some lawyers. I don't want to be wrong here. There are lawyers that do unbundled work. It's hard to find them, but they'll do it. But most of them find it's just better for them and their practice to have a client from start to finish and do all the work and bill for it. So I've watched this unbundled thing for many, many years all over the country. I've met with the IELTS people and everybody who's worked on this, and I just am skeptical it's ever going to go anywhere big time.
Thank you.
Thanks. Marcy?
Sorry, one more question. As far as malpractice goes, are LPs held to the same standard as lawyers?
Yes, but in our state, to be clear, we do not require lawyers to have malpractice insurance. So when this is coming up, some people say, well, we need to have the LPs have malpractice insurance. We said, well, we'll treat them the same way as lawyers. But our bar is pushed back to not require mandatory malpractice. We do require them in their agreements, they have to do a written client agreement to so state whether they have insurance or not. So we're doing the same thing with the LPs.
All right, thank you.
Now they have to have other insurance, you know, professional liability and so on, but we're not requiring malpractice insurance.
I'm sorry, professional liability?
Well, they're themselves as a business are going to have to make a decision of what insurance they want to protect themselves, various kinds of business insurance. They may choose to get malpractice insurance, or they may choose some other type of professional liability. I guess it would be the equivalent, that they don't have to have the professional liability part. Also, I should tell you, the LPs are required to become associate members of our state bar. And they actually are going to pay the same fees as a lawyer. That's been determined. And they're going to be in the client protection fund, and they'll pay into the client protection fund. And the client protection fund trust is being modified to cover the LPs. And any discipline complaints against an LP will go to the state bar and process the same way as a lawyer. Now, the ABSs are not required to become members of the bar, but the LPs are.
Interesting, interesting. Mac McCarley, I see your hand.
Thanks, Mark. Dave, I think I understood what you described for bundled services in the context of family law. What other branches of law does that apply to, and why do you think it doesn't get any traction?
Well, we actually just, I think, loosened that up somewhat, but because of the 5.4, because now you can have, and I'm not an expert on all of these areas, but you could have a law firm that contracts out certain services to another lawyer without the other lawyer being fully engaged in that case and having the same liability. So we have loosened those rules a little bit also to potentially create more association of lawyers even in a case. Now, I think until this time, because of fee splitting rules and referral rules, that's been very difficult to do. But we have loosened both of those up. So that remains to be seen what happens in Arizona. We haven't focused a lot on that, but it'll remain to be seen what happens with both referral fees and also lawyers associating in a more of an unbundled way because of the ability to split fees that we've authorized. You know, and our committee debated those things. I know these are some of these sort of like long-lasting ethical rules, but people stood back, and especially the public members of our task force, they said, now explain to me why this is a bad idea. It becomes very difficult to explain why some of these rules are there on referrals and fee splitting. Now, of course, all good things also have bad. I'm old enough in life. Every time you do something good, there's also bad, or there can be bad actors. So we'll still have to watch this and see that hopefully bad actors don't somehow get involved, do bad things. But it's not like we don't have problems now. I mean, we have lawyers doing bad things today.
Dave, was there any discussion about requiring a certain amount of pro bono or reduced fee work, given the focus on access to justice? I know there were complaints about the Washington program that after all that effort, most of the people were working in large firms or charging, fairly high rates. It didn't really seem to be targeting the folks that needed it. Did you guys think about saying, you can do this, but you have to give 500 hours of pro bono time, or you can't charge more than a certain rate? Any discussion on that front?
Well, not for just the LPs. I mean, we've had these debates and discussions with the lawyers for years. A mandatory pro bono, or the Jonathan Littman New York program, where you've got to do so many hours before you get admitted to the bar. Our lawyers have constantly pushed back on mandatory pro bono. Now we promote it, and we have an aspirational 50 hours a year, but we don't mandate it. And there's arguments. Conservative lawyers would argue it's a taking, and can you really do that? And others would argue, yeah, you can. So we're not treating these folks differently. They're going to be private sector folks and start a business, and they can donate time. The lady I mentioned in Prescott, she did quite a bit of free work for clients that came to her, and in the area of juvenile work, for instance. And so we think it's kind of up to the individual. We're not expecting to treat the LPs differently than the lawyers.
Thanks. Warren, you had a question?
Thanks, Dave. For my friends at the bar, does the state of Arizona anticipate any undue expense to the state bar in the operation of this new LP program? And if so, how is that going to be handled? How has it been accepted or perceived at this point?
Great question, Warren. The first answer is no. There'll be no expected expenses, but I mentioned that they'll become members of the bar. They'll pay the same dues. Now, the reason we can do the same dues is for the first 3 years that you're in practice, whether you're a lawyer or an LP, you pay reduced dues. And then after 3 years, it goes into a higher amount. So we thought that was fine to phase in the LPs, but they're going to contribute the same amount as a lawyer does to the state bar expenses. And they'll get the same services. They'll get the magazine, the ethics hotline, but the biggest portion of the dues goes to cover discipline for both lawyers and now to be LPs. The ABSs, we set up their fee structure so that a portion of their fees will go to the state bar to cover potential discipline cases and cover their expenses. So we built that, even though they're not becoming members of the bar, we built the structure in so we could give them a few $1,000s, I think it is, per ABS, and that'll hopefully cover their expenses. Now, interesting, you all asked me how it was, were people negative before this was adopted, and the answer was we heard more negativity than positivity from lawyers. But once it's been done, I've heard nothing but positive. Maybe people just gave up, but all sorts of firms and lawyers are calling me and said, this should have done years ago. It's great. We're going to be innovative, do all these things. So it really shifted to my surprise. And our bar board has really embraced it. They're kind of looking forward to the LPs coming, and it'll expand the offering in their magazine. It'll be more we call it CLE, continuing CLE. They'll be able to go to those classes, and so they'll pay the same fees, and they just think there'll really be an expansion of their membership. But one thing about bars is are you a mandatory bar state?
We are.
Yeah. So if you're a mandatory bar state, every member is already a member. You can't grow your membership. But this is a way a bar can grow their membership, because now you have a new group, and potentially this could if we have 700 new members over time, like document preparers, that's a new group, a new revenue for the bar.
Dave, do you know, is anyone planning to track the program going forward to collect data on, who they're seeing, how the practice is working out, the rates they're charging, all that stuff? I know this committee's been craving hard data on other programs to try to actually measure impact. Do you know if people are planning on doing that with yours?
We are. And if you read our codes, you'll see that there's a section where they have to report to us, and they have to get renewed every year or two. I think it's every year right now. As part of all that, we'll be collecting data from the ABSs as well as the LPs. Now, interesting enough, I mentioned we had these document preparers for 15 years, and nobody ever asked me anything about them. Nobody asked me for data. I mean, frankly, I didn't know what they were doing. They were just out there doing their thing. And so as part of this process, we did survey our LPs. Now we do have LDP data on what they do, the categories, and the money they charge and what they make. So if you want that, we did do a recent survey, and we have that data. But it's interesting. We're all, I think when something new comes along, everybody wants to evaluate. But here we had this program for 15 years, and I cannot remember one person ever that came to us and asked us anything about their information. But we do have some now.
That'd be great. Let's see. I see a few more hands. Mac and Marcy. Go ahead, Mac.
That was from my previous
Is that
question.
before? Okay. And Marcy, you have a new question, or are you from before as well?
Yes, I'm sorry. Something he said made me think of another question. Am I unmuted? Yeah. Okay.
We can hear you. Yes, go ahead.
All right. So Dave, do the LPs have to comply with the same CLE requirements as attorneys?
Yes.
Okay. Thank you.
But we're a
Alice,
state.
I thought maybe I saw your, I'm sorry.
We have mandatory CLA. Maybe you do too for attorneys. We also have it for all court personnel. We're one of the few courts that require every employee at every level, including our judges, to get 16 hours of CLE a year. So we're kind of a CLE state, but yes, they do same requirements. Suzanne Porter's on the line. Suzanne, I'm right about that, right? It's the same number of hours.
You are right about that, Dave. Yes. Hi, everyone. I'll be managing the ABS and LP programs here at the court with Dave and with Mark Wilson, the director of the Certification and Licensing Division. I've just been hovering in the background, but yeah, Rule 42 incorporates all of the ethical rules, and it applies equally to the LPs as it does to the attorneys.
And we were happy to get Suzanne. She comes from way of New York, then Canada, and finally came to her senses and is settled in beautiful Arizona. So she actually had some knowledge of these programs before she came to Arizona. So we're really happy to have her. She'll be the one. If any of you want to follow up, she's going to be our expert as we go along.
Yes, I'm happy to share my details, and you can direct any other questions to me after this session for sure.
Fantastic. Alice, did I see your hand up earlier? Did you? You're muted.
So I was curious about how about privilege? I mean, the rules of professional conduct are incorporated, but what about the evidence rules on privilege? How's that going to apply?
Our court put that in the rule that gave them the privilege. That's right, Suzanne, right?
That's right.
Yeah. So that we did consider that. And that's one of the areas they actually strengthen from the original petition I filed through our process. That got better, it was improved on, but they do have the privilege.
Great. Heidi?
Are the LPs allowed to maintain trust accounts?
Yes. In fact, like the family law ones would be required to have a trust account, I believe. Well, any of them that are in a practice area where they'd be receiving money. Again, I should double check with Suzanne, but I think all that applies. Is that right, Suzanne?
It is all of the ethical rules and all of the rules that are in place for those types of arrangements are in place for the LPs.
And one of the other groups that have stepped up have been our educational, both the community colleges and the universities. They were engaged really early with us on this. And I think we have 4 paralegal programs in the community colleges. And then we have 3 universities, but 2 of them have law schools. And one of them has a BS in law outside of the law school. But they also have LM, or what are the
LLMs?
Yeah, and other kinds of programs and certifications. Law schools have had to become more creative because of revenue. So they've stepped up and they've been involved in really embracing and encouraging this whole thing. And there'll be a great infrastructure to feed us potential LPs, and they're involved in helping to develop the test and all of that right now.
That's great. I don't think we can provide popcorn, but I understand through the wonders of technology, Brian's got the short little videos available where we'll be able to hear them. Can you see if you can tee those up and share those with us?
Yeah, I can do that. And actually, before I do that, Dave, I wanted to ask you real quick, could you talk briefly about public involvement? You mentioned that you've got some public committee members on that ABS committee. I was just wondering what sort of, how many people you had from the public, what sort of ratio you had of lawyers to non-lawyers and what their backgrounds were, and just kind of talk about their contributions.
Yeah, so back in 1978, I was hired, a young guy hired in this to come and implement a new program that used hundreds of volunteers, and it's called the Foster Care Review Boards. As a matter of fact, I'm thinking, the original Foster Care Review Board program was your neighbor state in South Carolina. But anyway, Foster Care Review Boards are boards of citizens that review children who are in abuse and neglect cases, and they make recommendations to the juvenile court judges on what should happen. So anyway, we wound up with hundreds and hundreds of volunteers, and they did such a good job that our Supreme Court many years ago made this decision, maybe it was at my urging, to put volunteers, non-lawyers, non-court people on all of our committees, all of our boards, including the state bar. And it was kind of a shock to the system, but it's been phenomenally good. And so our state bar, I don't know the exact numbers of lawyer members, there's probably 25 lawyers, 28 lawyers, but there are, I think, 4 non-lawyer public members that are now appointed, screened and recommended by the bar, but appointed by the Supreme Court. And then there are 3 more at-large members. And the at-large can be a lawyer or a non-lawyer. And so we have 7 right now, 7 that are non-lawyer members of our bar. And the same thing with our judicial council. We have probably 8 or 9 citizen non-lawyer members of our judicial council that regulates the court administration in Arizona. I cannot tell you how great it is to have those viewpoints. And citizens look at things differently. And just can't recommend it enough. And frankly, if we didn't have made that decision so many years ago, this would not have passed the State Bar Board, because the lawyers were initially just, normally reactive, negative to it. It was the citizens that said, oh, wait a minute, let's talk about this. And when they talked it through, they convinced the lawyers. So that's just something long-term to think. If you don't have non-lawyers on your boards, it really is refreshing, and it's a great thing. Gives you a lot of credibility in the community, particularly in a time right now where people are protesting the justice system's issues. And it's just great to bring other community folks who are not practicing lawyers and not court employees onto the committees.
Great, thank you. All right, I'm gonna share my screen and see if, tell me, Dave, interrupt me if I am sharing the wrong thing, but I believe this is what I found here on YouTube. Does this look right?
Yeah, well, it's either going to say triple LPs or LPs, because we changed the name, so that it's the same video. It's just maybe a different name. We'll see.
All right, here we go.
For a long time, anyone in Arizona who wanted legal help knew right where to go: a lawyer. Lawyers have special education and training. Over the years, they have developed legal expertise to help consumers. But these days, there's a problem. More and more attorneys are focusing on corporate work. That means fewer attorneys are available for regular people. And many of those regular people believe the cost of hiring someone for relatively simple legal needs is just too much. So, how can that problem be fixed? Well, Arizona's Supreme Court voted unanimously to introduce something new. It's called a legal paraprofessional, an LP for short. It's someone with legal training and experience, just not as much as a traditional lawyer. They can do some things a lawyer can do, but not everything. Think of it like a nurse practitioner. That's the professional you often see when you go to urgent care or to a routine office visit. For some things, it's quicker and cheaper. But if it's more complicated, you're referred to a doctor. The legal paraprofessional will work the same way. They'll be able to help with limited matters and refer you to a lawyer when your needs are more complex. They might work for a lawyer's office, or they might be out on their own. The result is better access to legal services for people in need. So remember, a legal paraprofessional will be someone with special training who is licensed and regulated by the court to give legal advice in very specific areas. They won't replace lawyers, just as nurse practitioners didn't replace doctors. But they could mean greater access to justice for the people of Arizona. To learn more, go to azcourts.gov/access to legal services.
All right,
That's great.
I think
Thank
that
you,
was
Brian.
I think that was it. I did find another one, Dave. I don't know if you were trying to show the ABS.
Yeah, that would have been the other one I would have shown. It's similar to that one. And just so you know, that probably cost me something like maybe $600 to have produced. And that was one of the tools we use as part of our marketing, if you will, when they go out to the public. We also produced, like the PowerPoint that I showed you, we built those. We built them both with these videos in them and without the videos. And then we made copies of those and gave it out to all of our members so they could go out and do presentations. That was just part of our plan to educate and, if you will, market the ideas. And if you decide to do something, I suggest you think about all of that so you don't just issue a report and think it's going to pass.
That's great. I'm putting in the chat for everyone a link to the LP video that we just watched, as well as the ABS video that's also produced. And I see there's one other one called Arizona's Legal Problem. I'll put that in the chat as well if anyone's interested.
Yeah, we did all three of those. The last one you just mentioned, sort of a broad overview of the problem and then what we're going to do about it. So again, that's just something we did to make available to a lot of folks, our focus groups and so on. You can see they're only about 2 or 3 minutes long, but I think it gets the concept out there pretty quickly.
Great, thank you.
Yeah, I think it's great. Thank you for sharing those with us, Brian. I think that's helpful. Well, if we don't have immediate questions for Dave, the other thing I wanted to do that really ties very closely to what we just heard from Dave is thinking of, and Mac, do you have a new question? I see your hand, but I can't tell if that's new or old. Go ahead.
Sorry, I was muted. Yes, it's a new question. Dave, after hearing all of this, I'm curious about something. What groups of people are still fussing about this? Who is not on board? Who's mad at what's happened? Who has not gotten on board to be part of this?
You know, Mac, it's really amazing. You know, I went to board meetings and we'd have 20 or 30 lawyers there, you know, loaded for bear to argue against all this stuff. Now I want to keep in perspective. We've got 25,000 attorneys, maybe 60 or 80 wrote comments, maybe 100 at the most. So it wasn't a huge, I mean, it was a vocal group, but it was still modest in size. But once these were passed, now, let's see, we passed in August, so it was even pre-pandemic. So I can't even say because of the pandemic hitting. I've heard nothing negative. I've had not one email from the lawyers being bitter. I'm sure they're out there. I'm sure people are skeptical and they'll wait and see, but I've had nothing from the legislature, nothing from the lawyers. Our court was unanimous, our Supreme Court. So it's just like turned off and we moved on. It's just, I think people are waiting to see. And I've heard many positive comments, particularly about the ABSs. There seems to be a big buzz out there amongst the firms starting to think about what they might do.
I was hoping you were going to say that there wasn't much opposition. I had no idea you were going to say there was literally none.
Nothing's happened, and I'm really surprised at it. And there's been no counter petitions. Now, again, maybe people will wait and see, and we're going to report back to the court every year for a while to what's going on here. And you know, maybe some of this won't work or will have to be tweaked. We recognize we may have to make adjustments, but it's just completely turned off. And then, of course, in fairness, the pandemic did hit, and people have been more preoccupied with that. And we're doing all sorts of stuff in virtual courts these days. But it just went dead silent.
Thanks.
Alice?
Dave, how big is your bar?
25,000 roughly, I think 26,000.
Okay.
Active.
And where are they mostly located? Are they mostly like in Phoenix, or are they spread out across the state? Or
well, of course, we have lawyers most places, but Phoenix, and most lawyers will be in Phoenix, and then Tucson is our second big area. Then we're very sparsely populated. But we do have counties, and that was another argument. We have one county, La Paz, there are no attorneys other than the judge and the county attorney. And we have another one, Mojave, where maybe there's 3 or 4 attorneys that practice civil area. So in rural Arizona, there's a dearth of attorneys available to buy. And we're really hoping we're going to get LPs out there in those areas. And that's one of the beauties of the education program that the U of A has, because it's online. And so people can be, hundreds of miles away from the University of Arizona and take these courses online. And so we're hoping that infrastructure is going to help us get people into rural Arizona. And this is a problem throughout America, rural America. How do you get legal services to rural America is a growing challenge.
Did you have any prior program of certifying paralegals or licensing them prior to this new program?
No, we authorize paralegals to work under the supervision of an attorney. We've never certified them. There's people occasionally have talked about doing that. And our state bar off and on had talked about maybe having a section for paralegals, but nothing ever moved on either of those until we've done this. And frankly, this might even open up that. It very well could be that the paralegals will decide that they'd like to have an associate member with the state bar, which again helps grows the membership for the bar. And that reduces the cost for all the lawyers, everybody, because your discipline overhead's what it is. And if your membership expands, the cost per person goes down.
Great. Well, and that, and we're a similar size bar. We've got 30,000 roughly here in North Carolina, but we do have for the last 15 years a certified paralegal program. And that's really the other thing I wanted to work into our discussion here is give everybody an overview of that program. Some are very familiar. We've got Warren Hodges who chairs that board, but I don't know, Brian and Alice, do you want to start off talking a little bit? Just, I think it's good for the committee to understand the infrastructure, if you will, that we already have around paralegals, particularly if we want to think about opportunities to, move in the direction that Arizona is going. I think it's good to know where we are and get an overview of that.
Sure. Thanks, Margaret. Alice, I don't know if you want to talk about history first, or if I can just provide a general overview of the program. Alice, of course, was the first director of the program, and I've inherited that spot. Had some big shoes to fill here. But Alice, what do you think? Do you want to talk about history first, or should I just give some brief stats?
Go ahead, Brian, talk about how the program functions, and then I can talk about history if it's wanted.
Okay. So the program, the Certified Paralegal Program, is a competency program in North Carolina. Of course, paralegals are allowed to be paralegals without having any specific license or anything like of that nature. They are our program. We currently have right around 36 to 3,700 certified paralegals. We have a number of different ways that you can qualify for the exam. Originally, it started off with an educational component. You could have a JD and be eligible to sit for the exam, or if you obtained a paralegal certificate or a bachelor's in paralegal studies, associates in paralegal studies, plus other kind of combinations thereof would make you eligible. But just, I guess this went into effect about a year ago. We added a work experience component that paralegals who have at least 5 years of experience in the paralegal profession could qualify to sit for the exam. Of course, they still have to take and pass the exam. But like I said, we're hovering right in that 36 to 3,700 certified paralegals here in North Carolina. They are all required to take to maintain your certification, which has to be renewed every year. You have to take 6 hours of certified paralegal education. And of course, that's just only slightly different from CLE. If you take CLE, that will qualify for your CPE. But generally speaking, I feel like the other component that I would mention is just the exam in general. And of course, we have our Certified Paralegal Program website that you can access through the State Bar's main website. But the exam that everybody has to take, whether we're talking about somebody who's got 5 years of work experience and sitting for this thing, or they just graduated with their paralegal certificate, is going to test them in these different areas: communication, research, analysis, documentation, and organization. Those are kind of the main, I guess we call them domains. And the tasks within each of those different areas can include understanding primary, secondary authorities, different procedural aspects, and things of that nature. The exam, we offer the exam twice a year. It is a multiple choice exam. It's 150 questions, and they get 3 hours to complete that. I would say that our pass rate is from year to year, and really from, I guess, just test offered, is right around, I'm trying to remember the exact numbers from this past year. I believe it's right around 60% of the folks that took the exam actually passed it. So it's a tough exam. It's not something that everybody just passes, but I think it's appropriate. Certainly, we do have a psychometrician that works with our program to evaluate the exam, make sure that the exam has integrity and that the questions are testing the appropriate things. To that end, we do have a paralegal certification committee in addition to the board. The board runs the program, but we have a paralegal certification committee that focuses on the exam itself, rewriting questions, determining are the questions asking the appropriate questions that paralegals should know if they're going to be certified to have achieved a level of competency. And I guess that goes back to just kind of the point of the paralegal program. It's to assist, similar to specialization in that way, assist the public in the delivery of legal services, that folks can go to a law firm, they go to a law office, and if they're working with a certified paralegal, they should feel confident about these services, the paralegal services they get from a certified paralegal. So that's my very brief overview. I know I'm giving that quickly because of time, But Alice, do you have anything else that you would want to add about kind of the origin of the program?
The main thing I would emphasize is that the program has always been one for raising the professionalism of paralegals, but paralegals who are working under the supervision of a lawyer. And the exam is very non-practice area specific. And so it doesn't, focus on family law skills or knowledge of evictions or anything of that nature. And that's where my concern comes from, any kind of suggestion that we can easily flip a switch and turn this into some kind of program that would be able to create licensed paraprofessionals that could go out there and operate really independently. It might be a start, but it's certainly not that was never the original intent, and it would require a great deal of real careful consideration about the requirements in order to turn it into something where I would feel at all comfortable about these folks providing services to people in the absence of direct supervision.
It actually, Dave, it reminds me of a question I wanted to ask you. You talked about the focus areas like family law or, the limited criminal or administrative. Are your paraprofessionals, is the exam going to be around certain focus areas? Like if I want to do family law, do I take a family law exam? And maybe this is a Suzanne question, or is it going to be one exam for everybody and then you can focus later?
There is one broad exam that deals with ethics and some general stuff. And then there's the case or practice specific areas. So you could get certified only as family law. Later on, you could come back and get criminal or civil justice court, and so forth. So Suzanne's working with a testing company now to develop those exams, but it will be for those specific areas. You could do one or all of them, your choice.
Alice.
And in addition to the exam, is there practice area experience that would be required? So for example, you're interested in the family law certificate, or I'm used to calling it certification, licensure. Would you have to demonstrate that you had a certain number of years experience working, in a law firm as a family law paralegal, for example?
Yes.
And if so, how long a time period, and how is that documented?
Well, Suzanne, if she's on still, might want to chime in.
Yep, I'm happy to chime in. So Dave already touched on the two different pathways to qualifying to take the exam as the first step. So there's the education pathway and the experience pathway. So the experience pathway that you're describing would be 7 years of the previous 10 years, 2 of which have to be in the area that you're seeking an endorsement on your license. We're calling them endorsements on the paraprofessional's license. So if they are coming through the education pathway and they are seeking a family endorsement, for example, then they would be required to have certain courses in family law, including 120 hours of advocacy training. So the way that will be documented before they can even sit for the exam would be through acknowledgements and state bar license of the supervising attorney with details of that experience or of that advocacy training and transcripts.
I will comment that on what you just described about your paralegals, that is a little similar to what Ontario had. They had paralegals were out there. I'm not sure anybody was exactly regulating them. And then their equivalent of the bar, the Law Society, took on this certification program and then put them into this program so they now can practice not only under an attorney, but on their own. So it was an evolution too. So if you have that program going, if you decided, of course, the next step could be, do you want to authorize them to practice on their own or go into court, that kind of thing. You could take those steps. But I would commend Ontario to you. They were very helpful to us, and you'd learn a lot from their experience. They've been in the business for over a decade.
Thanks, Dave. That's helpful.
And they're also expanding. I think their paralegals, my memory is they did predominantly criminal law, actually, and civil suits, and they're now expanding, or they're considering expanding into the family court area, I believe.
Dave, did you consider doing like a pilot program with a limited number first? I know we've heard about regulatory sandboxes and other jurisdictions and the idea of testing some of this out. It seems like Arizona's jumping in with both feet and, opening it up to everybody. And I see pros and cons to doing it that way, but I'm curious whether you had debates about, doing this incrementally as opposed to throwing a switch and saying, welcome, welcome everybody.
Well, all that was talked about and debated, and the conclusion was to go the way we did. But keep in mind, this didn't just spring up overnight because we had the document preparers and that experience. We've had experience with fiduciaries, other groups that we already regulate. We've tried self-help centers. We have the AmeriCorps program like Navigators. So we did a lot of other things that led to this. But then when you get down to it, you say, well, pilot it. I wasn't sure if my court was going to say, well, let's do this for 5 years and we'll see, or what. It's hard when you start doing a pilot because people tend to practice in more than one jurisdiction. So it's hard to do, figure out how you're going to do that. You can say you're only going to make these available in Maricopa County or a rural county. But my court, I think, wisely didn't put a limit on this, because that part of this is to attract capital into law firms also, and companies coming into Arizona. And they're not going to do it if you're going to have a 2-year pilot and then they may be out of business. Now, our court could always change the rules. I mean, everybody recognizes that, but we decided not to go that route. But one other group we did pilot, or we're trying to pilot, is, I didn't mention them, but they're called domestic violence advocates. And these are folks that work for shelters, and sometimes with or under the supervision of a public defender, but generally not. They mostly work with shelters, and they've been authorized to be able to provide assistance, take a course, get certified, and then provide assistance to victims of domestic violence in related areas. So that would be going into an order of protection hearing, a domestic violence case, sometimes then it goes into family, divorce, or custody, and also it can get into eviction because there's special laws when you're dealing with domestic violence. So those folks were also authorized, and there was a pilot. There's a pilot in Tucson, Arizona, run by the U of A that's just underway, and then our Bar Foundation is going to run the other program in the other counties, and we're going to evaluate whether those work. So now they have been slowed down by COVID because people have been reluctant to come to courses and so forth, but I think they're going to get going now.
Thanks. I know we have Warren here, who is our chair of the Board of Paralegal Certification. Warren, do you want to share a little with the committee about what the board's doing? I obviously you're pretty immersed in this, so I welcome your thoughts on what we've been talking about today.
Well, with Dave as the forerunner today, I'd like to hide in the shadows. And Alice and my friend Brian and Joy do all of the work. So I just sort of stand around and I'm the pretty face. But it's a great program that we have now. It does exactly what Alice and I and Brian hope it will do. It does bring some credibility to some of the graduates from paralegal programs around the state. But at the same time, in a realistic view of the economics of the practice of law in North Carolina, it also produces graduates who struggle to find jobs outside of the bottom tier of those lawyers who are struggling economically. And so the story that motivates me when I'm coaching my students is the lawyer who called me up the third time and said, I don't understand why you can't send me a new graduate. I can pay $10 an hour. I can guarantee 30 hours a week. And one day we'll have benefits. And I'm not making these up because you all know that the practice of law is an economic struggle for so many. So the certification program, in my opinion, runs very smoothly. It does exactly what it was designed to do. And we direct graduates to law firms that are profitable and to agencies and government offices and corporations where they can also work and earn a good living. But all of that brings me back to the 5 years I spent in legal aid and the problems that Dave began with today, and the fact that most Americans cannot afford to pay a lawyer to represent them. And so the things that we've seen, I understand, and I'm looking forward to what North Carolina will do. Could we take a switch and just flip that switch and say to Brian and Alice and the bar, hey, just flip this over and let's do this legal paraprofessional program because you've got it all down? And the answer is no. But we could see the certified paralegal program and the way that it was created and the way it's structured to be a formula or a structure by which we could organize and design a new program. And just as Dave described, you could have law firms that had certified paralegals, and you could have law firms that had legal paraprofessionals in them, and students and graduates could choose their path, and it would give us another opportunity. The one comment I'll make, just so that you kind of know where I am, is yeah, I'm on this board and I teach at Forsyth Tech, but I teach at a school in Oregon. And I had a conversation with my supervisor in Oregon where I teach online. And she said, why are you slow in your grading this week? And I said, I'm terribly sorry. But I have a 2-hour conference call this afternoon and I'm trying to prepare for that. And she said, the Oregon bar has me in a 2-hour conference call every week. And they're now going to make me rewrite my curriculum so we can do limited liability. And so I need to call her back and find out what they're doing in Oregon. All of that's to say, I think it's a great thing that we're doing what we're doing, and we can develop a program. And from Dave's conversation, maybe we look at using the structure that Alice shepherded starting in the early 2000s and create a separate structure. But I would concur that you can't flip a switch. You can't take the program that we have today and turn it into suddenly turn it into a licensing program. And my last thought is for Suzanne. Suzanne, everyone in my extended family lives in Canada, and I look forward to some conversations, and most of them live in Ontario, and they've never complained a minute that I'm a lawyer. So that's all I've got.
Yeah, Mark, one thing I'll mention for the states that are like yours interested in this, the state courts are divided into regions. And so I'm in the Western region. And we hold normally a conference each year on a given subject. We were supposed to hold our conference in Anchorage last May, couldn't do it. And it's going to be on this topic, the delivery of legal services. We were going to do it May this year. We just met yesterday and decided to do it in September. And we'll probably be doing it in either Arizona or maybe Santa Fe or Las Vegas. But anyway, the reason I make this point is we're going to have a conference and bring all of the Western states together along with some of the national and international experts. And on occasion, we have interlopers from other regions that come to our conference. But my experience has been that whatever the Western states take up tends to spread. And the other regions then tend to take that same topic and talk about it. It's happened with mental health, with bail reform and other topics. And so if you're interested, you might try to stay in touch with get your chief justice or somebody from your court to go to the Western Conference on the delivery of legal services, which will probably be in the fall, probably the week after Labor Day here in the West Coast somewhere. Because when the justices get together and talk and hear this stuff and then talk informally, it really starts to get legs. And whatever you decide to do in North Carolina probably will be different than Arizona, but there's steps you can take with what you've built already. I could see several opportunities for you. You just got to think through what makes the most sense. Where's the need? What can you do politically? What can you get accomplished? And I'll tell you, we already have our first expansion of LPs. We've been talking with our Minority Commission and our Judicial Council on racial fairness and justice. And a recommendation was made to authorize the LPs to appear in bail hearings. Now, you may have lawyers at your initial appearances, We don't. They don't get an attorney appointed for several days or weeks afterwards. But we know that if you have somebody there arguing for no bail or no cash bail, other kind of release conditions, it's much more likely you'll get them. So I'll file a petition this week, actually, to authorize that. And it's our public defenders who are looking at being able to hire them or even, get them to be able to go into and appear in initial appearance court. So that's already happened. We don't even have our first LP yet. So I just wanted to mention that to Warren because of your background with the public defenders. They've asked to expand into that area.
Great. Camille, I see your hand.
Yeah, just quickly, I was going to say that the National Association of Legal Assistants has a certification program that has special, areas of practice specialty. There are, I don't know how many of those there are in North Carolina now. I think the numbers have probably decreased because of the North Carolina certification program. But, I was certified under the national program. And so I took a litigation specialty exam and had, many, many friends across North Carolina who were nationally certified and had that specialty in their area of practice.
Great. Any final questions? I think we're coming up on the 5 o'clock hour. I want to respect everybody's time and I don't see any. So Dave, thank you so much. I really appreciate you being here. Suzanne, you as well. Warren, all of you provided a lot of good input. We're going to have another meeting and what we're going to do in the meantime, I've talked to Alice and Brian, we're going to send out a survey for all you committee members listing all the different innovations we've heard about, including the idea of a legal paraprofessional, and really going to ask you just a few questions. Do you feel like you need to know more? In other words, do you need more education or are you content with what you've learned? Do you think it's a good fit for North Carolina potentially? And again, we're not proposing anything specific from this committee. It's more of a sense of, yeah, this might be a good fit or no, it isn't. And then a brief explanation of why. And I'm going to use those survey responses at our next committee meeting to kind of come up with what we can, see if we have a consensus on which of these innovations seem most likely to be of interest for further study and begin to formulate some recommendations coming out. And I definitely think there's some more things we may want to learn about, including, the idea of people being in the courthouses and other stuff. So I'm not suggesting our learning is an end. We've learned a lot in these meetings, but I do want to kind of take a pulse of where we are. If we think we want to learn more, and maybe a sense of where, if there's a consensus around ideas that we want to continue to explore or ones we don't. So that's what's ahead. Look for the survey. We'll get another meeting on our calendars. And I appreciate you all taking the time. We've used our full 2 hours, which we don't always do, but we had a lot of great stuff. And again, thanks for your questions, Dave, wonderful presentation, and for all you're doing out in Arizona. Exciting stuff. And it's great to see someone else charging into the great unknown. And we can learn, watch, and listen. And I think we really appreciate that opportunity.
Thank you all.
Thank you.
Thanks, Mark. Thank you so much, Dave. Thank
Bye.
you, Suzanne.
You're welcome. Bye-bye.
Thank you, Dave and Suzanne,
Thanks,
very much.
thanks everybody. Hope the rest of
Nice
your
to
week
meet
goes
you all.
great.
Bye-bye.